In modern civil litigation, a perfectly researched legal argument is useless if it is housed in a procedurally defective vessel. That vessel is defined by Rule 7 of the Rules of Court, which dictates the exact anatomical requirements of every legal pleading. Prior to the 2019 amendments, pleadings often served as simple, evolving narratives where evidence could be held in reserve. The current rules have stripped away that leniency. Today, a pleading serves as a certified forensic warranty, a hardline defense against speculation and judicial delay. We're going to forensically build a pleading by mapping sections 1 through 6 of Rule 7, isolating the exact rules, the narrow exceptions, and the bar examination pitfalls hidden within the text. Mastering these procedural tripwires is the baseline for surviving both real-world litigation and bar hypotheticals. Section 1 establishes the caption. This serves as the formal introduction of the document, ensuring precise administrative cataloging within the judicial system. The rule requires 3 components at the top: court name, title of the action, and docket number. Examinees must avoid the et al. Trap in initiatory pleadings. The court must definitively ascertain every claiming party's identity from the beginning. Below the caption is Section 2, the body. This mandates a structured format of paragraphs and headings so that opposing counsel can isolate and respond to each claim. The body must contain the pleading's designation, a methodical layout of the ultimate facts, the relief prayed for, and the date. Failing to date the pleading or burying multiple ultimate facts into a single massive paragraph violates the formatting requirements of Section 2. Sections 1 and 2 lock in the architectural framework, establishing the court's jurisdiction and defining the precise scope of the controversy. Section 3 introduces the signature and address. By signing the document, the lawyer or party establishes personal legal accountability for its contents. Every pleading must be signed by the party or their counsel. The address provided must be a physical location. Utilizing a post office box is prohibited because the court requires a physical point for service. A counsel signature acts as a strict legal certification, mapped by the mnemonic read. The lawyer guarantees they read the pleading, it is not filed to harass, factual contentions have evidentiary support, and denials are warranted. An unsigned pleading produces no legal effect. While courts may allow a remedy if the missing signature was due to inadvertence, the default status of an unsigned document is a legal void. If a lawyer deliberately files an unsigned pleading or violates their read certification, they are subject to disciplinary action by the court. Section 3 attaches an actionable warranty to the signature, turning a procedural requirement into a tool for professional discipline. Moving to Section 4, we encounter verification. This elevates the pleading into a document sworn under oath. The general rule is that pleadings do not need to be verified unless a specific law or procedural rule requires it. When required, affiants must swear allegations are true based on personal knowledge or authentic records. Non-par mechanism used to filter out overlapping claims. Forum shopping is filing identical lawsuits in different courts, attempting to game the system by hoping at least one jurisdiction grants a favorable ruling. To prevent this, the principal party executes a sworn CPR certification. They certify they have not commenced an identical action, no such action is pending, and they will report any similar action within 5 days. Unlike the signature on the pleading, counsel cannot sign the certification. It must be executed by the principal party, unless highly justifiable reasons are presented. Failing to include the certification results in dismissal without prejudice. Submitting a willfully false certification results in dismissal with prejudice. This requirement cannot be cured by simply amending the complaint later. Section 5 ensures the court's resources are spent only on unique controversies rather than duplicated judicial gambles. Section 6 eliminates trial by ambush by requiring the disclosure of all supporting evidence at the moment of filing. Parties can no longer hide evidence to surprise the opposition. They must lay all their evidentiary cards face up at the beginning of the case. Pleadings asserting a claim or defense must include 4 attachments, known as WSJE. You must state witness names, summarize testimonies, attach judicial affidavits, and append all evidence. At trial, you can only present witnesses whose affidavits were attached on day 1. The court may admit additional witnesses or evidence only if a party presents meritorious reasons, such as evidence that was newly discovered despite due diligence. This applies to all pleadings asserting a claim or defense. Defendants must meet these evidentiary requirements in their answers and counterclaims, just as plaintiffs do. By locking the evidentiary record at the pleading stage, Section 6 forces parties to prove their readiness long before the first hearing begins. Rule 7 functions as a procedural filter designed to trap defective or frivolous claims before they can consume judicial resources. Sections 1 and 2 lock in the identity of the parties and the scope of the controversy. Sections 3 and 4 lock in the lawyer's professional accountability and the sworn truth of the allegations. Sections 5 and 6 ensure systemic integrity by purging duplicate claims and forcing evidentiary transparency. Under these rules, a procedural defect is swift and can be fatal to the case. You must master the procedural vessel. No matter how strong your substantive law argument is, if your pleading fails Rule 7, you will never see the inside of a courtroom.